And welcome to today's elder care presentation. I want to thank Mary for joining us today. Mary Patton is an elder law attorney and a member of the Bluegrass Elder Law team here in Lexington. The reason I think it is so important that she is with us today is, and it just kind of hit home. Last week I was at a class, and the presenter of this class for part of the session brought in 3 former caregivers and asked them what they thought the most important things were that their providers, social workers, community information folks gave to them. And unanimously and instantaneously, they almost all said together what legal documents they needed and how to get those prepared. That was the #1 thing they said. It was primarily, it's just so important because it's inevitable that emergencies are going to come up, and at end of life care, things like that you don't want to be thinking about. But anyhow, I was just so excited that Mary's coming today to talk to us. So I'll let Mary take it from there. Bye, everyone.
Okay, so I turned my mic on now, so if I'm muted on Zoom or if I'm muffled on Zoom, let me know and I'll readjust my microphone. All right, as you said, I am Mary Patton. I'm a partner at Bluegrass Elder Law, which is an estate planning firm in downtown Lexington. We also do a lot of long-term care planning. I just recently stepped down as chair of the Bar Association's Elder Law section. Oh, and this, I apparently did not update this. I just stepped down as president of the Fayette County Bar Women's Law Association. Last year was a very busy year, and I told people this year I'm saying no to things. So, but I said yes to this. So, I also wanted to let you all know a little bit about my background, so you know I'm just not some random person who walked off the street. So I've been practicing in this area for about 12 to 13 years. My first job out of law school as a brand new attorney was as a staff attorney for a probate court judge. So when I talk about these things, it's because I've seen them go right and I've seen them go very, very wrong. I've seen them so wrong that it costs thousands and thousands of dollars going through the legal system, sometimes hundreds of thousands of dollars. So I don't want my clients to have to go through those situations. And I want you to leave armed with information about how to protect yourself, your family, your loved ones, and your things. As I said, my firm does estate planning and long-term care planning. As a firm, we really focus on doing holistic planning for our clients. So if a client comes in and says, I just need a will, I'm going to ask for more information. So we need to know a lot more about the person before we create a plan. So kind of keep that in mind, the things I talk about today. If you have a very specific question about something, my answer is almost always going to be, it depends. Because a lot of stuff is really factually dependent on what's going on in your life, in your family, and things like that. All right. So today, my big goals for you are that you're introduced to some of these legal tools that are available. You leave understanding basically what they are. And I provide you some resources to figure out what you need or what your loved ones need, okay? All right, so why do I talk about planning now? Does anybody have a crystal ball or a fortune teller? I am not. So I like to tell people we need to plan now. So all of the stuff I'm going to talk about today, I have done for myself. I'm younger than some of you all. I might be older than some of you all. But I have no idea what the future holds. So I may need my husband to use my powers of attorney before I get out of here today. I just don't know. The future's uncertain. And I like to tell people that youth and health is not a magic ticket to having enough time. We just don't know. So the other thing I like to be aware of is that, unfortunately, as we grow older, our competency just naturally lessens. It's just part of the aging process. I like people to plan now because it gives us time to actually make informed decisions as opposed to reacting to emergency situations. Okay, so As earlier, I just mentioned competency, and some of you all may have loved ones who might have some competency issues or being diagnosed with some dementia or Alzheimer's. So I like to always tell people that that diagnosis itself doesn't mean that you can't do planning. Doesn't mean that your loved one can't do planning. Competency is a sliding scale. It's not black, it's not white. There's a lot of gray in the middle. In the state of Kentucky, we recognize something called the lucid interval. That means an individual who has Alzheimer's, who maybe in the morning has a really good grasp on what is going on and is oriented to time and place and people, she can execute documents in the morning that she may not be able to execute in the afternoon if she has sundowners, for example. So I always like people to be aware of that. A lot of people call our office and say, you know, my dad's been diagnosed with dementia. I don't know what to do now. He can't sign legal documents. And I say, well, what do you mean he can't sign legal documents? And they say, well, he has a diagnosis of dementia. And I say, does he know who you are? And inevitably, you know, usually they say yes. And then we go a little further to find out whether or not the dad can actually sign documents. So, all right. So, getting to the meat of this. This is what you all need. This is what I suggest everyone needs. The first thing is just a list of your stuff, okay? Even if you have all of the other things on my list, if your loved ones don't know where your stuff is, it's gonna take them a lot of time and energy to find it, to find out what you own. So clients who come to my office usually leave with a 3-ring binder with all their documents in it and pockets. I tell people to update their list every year. Your list may not necessarily be a list. It might be just be a copy of an annual statement. And that's so your loved ones know where your stuff is. Last year, we had a life insurance policy that we knew that one of my clients had been paying for. And then they passed away. We had no idea who had that life insurance policy. And it took us several months to find it because there's not just like a magic place where you can enter someone's name and social security number and find all that information. And unfortunately, the person administering the estate was not the beneficiary. It was somebody else completely. So this person did a lot of work to, get no payoff in the end. She didn't mind to do it. She loved her family. But I was just like, that just feels kind of bad that she did all this work trying to find this stuff. So that's the first thing I tell people to do. The next 2 documents are both powers of attorney. I split mine up. One's for legal and financial affairs, and one is for healthcare. And then I always suggest a living will and a last will and testament. Now I'm going to talk about these specific legal documents further. All right. So if you leave here with one piece of information today, it's that I want it to be that you need a power of attorney. Okay. I think these are the most important estate planning documents, and I think most of my caregivers would probably agree this caregiver Terry was talking about. So a power of attorney is a written legal document where you give someone else, who we call your agent, the authority to make decisions and do things on your behalf. So I always suggest that it means at least one person and one backup, maybe more, because again, we don't know. For example, in my power of attorney, my husband is my primary agent. And if something happens to him, it becomes my father. So our children are too young right now to act. So I imagine I'll update that eventually. But right now, I wouldn't want my 7-year-old and my 9-year-old in charge of like my finances. So I always suggest, if possible, to name somebody in a generation lower than yours. So it might be your spouse, and then and for me, my spouse, my dad, and then it could be my niece who is of age. Would be an appropriate person. And then I always tell people to think about who to name and who you trust. Think about giving this person basically the PIN code to your debit card and the keys to your house. It needs to be somebody trustworthy. I did have a really nice lady once who came into my office, and she had a very close relationship with her grandson. Her grandson lived with her because he had just been released from prison for forging her checks. So we decided that he was not an appropriate person to name, despite the fact that they had a very close relationship. She said, I don't think I should name my grandson. I was like, I don't think you should do it. So that's why I tell people to really think about it. State law controls these documents, so the state that they are signed in will control what makes them legal. Most states have provisions where they will accept a power of attorney that was drafted in another state as long as it met the requirements there. So just making sure that that covers those things. So I'm going to break down powers of attorney even further. That's how important they are. I'll talk about them more. So the first power of attorney is the legal and financial power of attorney. So this one is obviously going to cover financial affairs, and it should give a very specific list of things that your agent can do. It should talk about bank accounts. It should talk about brokerage accounts. It should talk about life insurance. I also like my agents to have the ability to access accounts online electronically. As our society becomes more dispersed, it's not unusual for us to have loved ones living in other states who we still have a very close relationship with, and who may be an appropriate person to assist us with those affairs. So I like the ability to do online banking and things like that. Your agent should have the ability to sign contracts on your behalf, to deal with your real estate if you own any. And then the hot button thing that we talk about in my field is gifting. So you have to decide whether or not you trust your agent to make gifts on your behalf. So, and people who come into my office, we talk about this really in depth because I want to make sure you understand and that you trust that person, because generally we give them the unrestricted ability to make gifts on your behalf. Now, some of that is for Medicaid planning if we need to do some of that down the line. But in general, we really want to make sure that where you want your money to go and that your agent understands that as well. The legal and financial power of attorney should also have the ability to access healthcare information in order to pay your bills. So we want them to be able to call, UK's hospital's billing department and be able to figure out what needs to be paid for. And then you can always choose to pay the agent under your power of attorney for things they do for you. All right. There's also a healthcare power of attorney. This seems pretty straightforward. Basically, this person needs the ability to access your healthcare information, and this person has the ability to assist you with making decisions until you lose competency. When you lose competency, they have the ability to make decisions on your behalf. I'd like to highlight the fact that this person can act. For example, on my healthcare POA, my husband could call my doctor's office right now, write his healthcare POA, and be able to give information for me. So despite the fact that I'm obviously competent and still here. Yes, we have a question.
So what triggers a power of attorney? I mean, you get this thing signed, this document, you go to the safe somewhere, hopefully never to be used. What triggers it?
Okay, so the question was what triggers a power of attorney? So the thought was that you sign it and you probably stick it in your lockbox or a safe, and what triggers the need to use it or makes the power start. So there are different ways to do that. There are two types of POAs without getting too technical, because you have to remember I'm a lawyer, so sometimes I talk like a lawyer and I apologize. There's something called a springing power of attorney, and that power of attorney is a power of attorney that only springs into action when something happens. So typically that's letters from two physicians indicating the person has no competency. Has anyone ever tried to get a letter from a doctor? What about two doctors? Okay, so in general, my firm does not do those springing powers of attorney because the problem is we spend the time and energy to draft them, and then if a doctor won't sign off, or let alone two doctors won't sign off, the document never really goes, it never really works. So in our office, we do powers of attorney that are active when they are signed. Now, our hope is that someone would take it home and put it in their lockbox, and hopefully their agent knows where it is, and so if something happens, they know where to go and get it. So it just depends on what type of power of attorney you have, whether you have one that's active when signed or if it's springing. So
I do have a question. If you have a power of attorney, but maybe the person that is in charge who doesn't live in the state, can you send them a copy so they have that, or does it have to be the original document?
Okay, so the question was, if you have named an agent who lives out of state, should you send them a copy or do they need the original? So I'm going to tell you it probably depends. Most of the time a copy is fine. The only time you would need the original in the state of Kentucky where it would be legally required is if you were going to transfer real estate, and then you would need the original. So I'd like to let people know that. Okay, The healthcare power of attorney needs to have HIPAA waivers in it. The Health Insurance Portability and Accountability Act, if it doesn't have that waiver language in it, it is unlikely that medical staff is going to talk to you. I see a lot of powers of attorney that come from different parts of the state. If your power of attorney is 1 or 2 pages long, it's not long enough. My legal financial power of attorney is 10 pages long, my healthcare one is 8. Just because that is the way the law is changing and the way, for example, financial institutions, they really want everything spelled out in detail. The other thing I'd like to remind you all about is that, like I said earlier, every state has its own signing requirements. Kentucky changed theirs in July of 2018, and it is a very strict standard as far as POA standards go for execution. So it requires your signature, the signature of 2 witnesses and a notary. So if you have a POA, it really needs to have all those things on it if it was signed after July 2018. Unfortunately, I'm still getting a lot of POAs, again, from other places that don't follow that requirement. And it's unfortunate. It used to just be a notary or 2 witnesses, and then the legislature decided to change it. The legislature added a bunch of great stuff, and then someone added this one requirement, which I was not a fan of. But the new POA laws really attempt to force financial institutions to take the documents, because that's usually who's giving us grief, is you take it down to ABC Bank. ABC Bank says, well, I don't know, I have to send this up to my legal department. And ABC Bank's legal department sends down some sort of memo that says, you know, Mrs. Jones really needs to sign our power of attorney document. Well, Mrs. Jones might be incompetent in a coma in the hospital. She can't sign that document. So the new Kentucky law does allow basically provisions for if that financial institution is not going to take that document, they have 7 days to inform you. And then there are things they can do. They can ask for an attorney to write an opinion about whether or not it is, you know, executed properly and if they should take it. They can ask for more information. But after a certain period of time, if they do not take it, you can actually file suit. I know one of the local banks here has been, since this law has been passed, has been sued about 3 times because they won't take the documents. And so you imagine, you know, as soon as it gets filed, they magically are like, oh, this POA looks fine. But it has been a problem in the past. So before this law was passed, I had a lot of difficulty with one particular financial institution who wouldn't let my power of attorney agent, the agent under the power of attorney, change the mailing address. The document was going to, it was like a married couple and the wife had died, and they were still sending the document to her at the nursing home. You can't forward mail from a nursing home. So that wasn't an option, and it was very difficult because it was so silly, but they wouldn't take my person's power of attorney. So, alas. Okay. All right. I'm going to move on from powers of attorney to living wills. So a living will is different from a healthcare power of attorney. Sometimes, depending on the person drafting them, they might weave them together, but in our office we do these differently. Under the statute, which these are a statutory document, a living will is a document that only goes into effect when a person is terminally ill and permanently unconscious. So this is really a document that only goes into effect when you're in a vegetative state. So this is the document where you can indicate what type of life-prolonging treatment you want, whether or not you want artificial feeding or hydration, and what your thoughts are about organ donation. So I waited personally to sign this until I had surgery, because I knew if something happened to me, it's just routine surgery, but if something happened to me, my mother would try to keep me alive forever as a vegetable, and I don't think that probably would be the best thing for my husband and my children. So I didn't want to become the new Terry Schiavo. So I signed one of these. If you all remember Terry Schiavo, this is the reason. I really like those documents. And so again, these documents only go into effect in those end stages of life. So if you go into the hospital and you've had a heart attack, but you're alive and breathing and can indicate what type of care you want, this is not the document that automatically kicks in because you've not reached the state where you're terminally ill, permanently unconscious. Does that make sense? Okay. I get a lot of questions from people who think if they go into the emergency room that they're not going to be able to get anything. And I'm like, no, it doesn't work that way. And I have a couple friends who are doctors, and I talk to them, and they're like, we try to keep you alive as long as possible. And I was like, that's what I thought. So let's talk about the last will and testament. So this is the estate planning document most people are probably familiar with. So this is a document where you appoint someone to administer your estate after you pass away. It outlines how you want your things given away. And then I also suggest that it creates some sort of backup plan as well. I mean, for most individuals, we have wills where we say, I want everything to go to my spouse, and then I want everything to go to my kids if my spouse predeceases me. So that's one backup plan. I like to take it a little further because, I mean, the world is just rife with terrible examples of this. But if we're on a lovely family, it's the family vacation catastrophe. Okay, so if all of us go to Hawaii but we don't make it back, where does your stuff go to? So unless you state otherwise, it's going to go to the people who it would go to under the statute. So in my case, it would go to my parents. Well, my parents don't need my stuff. So my niece gets all my stuff if all of us die in a lovely plane crash in Hawaii. So, I mean, that's just one example. So I had a lot of people tell me that my job is very morbid, and it is, but my job is to think through all the terrible things that could happen so that your estate actually goes smoothly. So if you don't have a will, the government has already decided where your stuff is going. If you are married and have children, your spouse and your kids split your stuff. So for example, right now I didn't have a will and I died owning something that would go through probate. My husband and my 2 minor children would own halves of it. So I'm sure that my husband would love to manage things with my 7-year-old and my 9-year-old. So I have a will that keeps that from happening. Additionally, as I said, talked about holistic planning earlier, you have to draft these documents while understanding what you own and how you own it. So I think if you all work for UK or have worked for UK, you all probably have some sort of retirement plan. Most of those retirement plans have beneficiary designations on them. A beneficiary designation is a contract between you and the person who holds your retirement account. Your will does not affect that. So if I have a will that leaves everything to my husband and I change the beneficiary designation on my account to the pool boy is going to get my retirement account, not my husband, despite the fact that my will says otherwise. So I just always like people to understand how that works. Because I had clients who came in last week who their beneficiary designations had gotten messed up. And dad died, and instead of leaving everything to wife, it was left to their 2 children. And that was not the plan. And the daughter said, well, it'll be okay because the will says that mom gets everything. I was like, that's not the way it works. So we found another way to fix the problem, but it would have been a lot easier not to have to go through that. So I always tell people when they're doing their planning, they need to check their beneficiary designations. Beneficiary designations can even be on your bank accounts. In some states, you can actually have a beneficiary on your real estate, not in Kentucky. So it's really important to understand how you own these things and how they're going to pass when you die. If you own a home jointly with rights of survivorship with your spouse or with another person, it automatically belongs to them when you pass away. However, you can also own a house as joint tenants with your spouse or another person. And notice there's no survivorship language in that. So that would be an asset that would have to go through probate. There's a question in the back.
Are you going to talk about trust at all?
I am going to talk about trust next. The question was, am I going to talk about trust? And I will. Yes.
Why do people want to avoid probate?
Okay, the question was, why do people want to avoid probate? That's excellent. Oh, if only I had a slide on that. Wait, I do. Okay. So people, I think avoiding probate is an overblown problem. Probate, and I will tell you, I practiced law in Ohio before I practiced law here. I'm actually from Lexington originally. I went to college here and I thought it would be fun to live in a different state for a while. It was not, I'm back. Kentucky's much better. Yes. So Probate in the state of Kentucky is very simple. It's a very relaxed process. It costs out of pocket about $300 and takes about 6 months or so, just depending. Now, probate in other states is much more expensive and takes a lot more time and energy. Now, because I used to practice law in Ohio. In Ohio, I swear to God, if you sneeze, you need a sworn affidavit during a probate. Like, that's what it feels like. Anytime something happens, you need notarized proof of something going on. I'd be a lot more, I would want to avoid probate more in other states. States like California and Florida are notoriously difficult and expensive. Kentucky is not one of those states. The first time I did a probate here, it was so simple, I thought I had done something wrong. So if your family in general gets along and will work together, it's not a problem. That doesn't mean there aren't some problem children. Especially if you have a will that sets forth what exactly your wishes are. So we go to court and someone gets appointed, the person who you want to get appointed becomes your executor. And then that person has to file an inventory within 60 days. So that's just a list of what you own. And then just a general list, we don't actually go through and count each teaspoon. And then within 6 months, they can close the estate. And so they can distribute the property to the people it goes to. Those people can sign a receipt saying they got what they were supposed to get. And then we file it all with the probate court and it's done. It's so easy in Kentucky. So in Kentucky, not an issue. However, there are some people who want to avoid probate. And there are good reasons to do that for some of them. Some people who have a lot of privacy concerns, or they have problem heirs, things like that. And so I will talk about trusts in just a second. Trusts are really the way to avoid probate, okay? Any questions about probate? Oh, let me talk about what goes through probate. How about that? So property subject to probate is property you own in your own name. It doesn't have a beneficiary designation on it, and you don't have a joint owner who has a survivorship interest. The most common probate asset I get is a car, because a lot of people just own them in their own name. There's no beneficiary on a car, so that's your primary example. Okay?
But you can't put a car in trust, right?
The question was, can you put a car in trust? You can, yes. Is there another question?
Yeah, so in my case, like, the house was not in my name, it's in my wife's name, and paid for a long time, but, do I own that house?
So the question was, the house is in my wife's name. It's paid off.
Yes.
Do I own the house? The answer is no, you don't own that house. Your wife owns the house if it's in her name. And so it would be a probate asset.
And I wouldn't get it because I'm the husband? She dies first?
If she dies first, it depends. If she has a will that leaves you everything, you would get it. If she doesn't, you would get half the house. And if she had kids, they would get the other half.
Okay.
So sometimes that works, sometimes it doesn't.
Can probate protect you with debt too? I mean, if you are not involved with debt?
So the question is, can probate protect you
From debt
from
that
debt.
you don't owe? I mean,
So,
you're-
yes, so,
involved with someone like my husband died, and that was 5-6 years ago, and I went through that because he had debt that I did not owe. And
so essentially the question is, for basically a married couple, if a spouse dies and they have a bunch of debt, can it protect the other spouse? And the answer is yes. The estate is open for 6 months to take claims from creditors. And I always tell people, you're not personally responsible for someone else's debt. So after that 6 months window is closed, there's a couple exceptions, being with the federal government.
right.
But in general, after 6 months, if they don't file a claim, they're just out of luck. And so, and while that's unfortunate for those creditors, what it does is it creates a clear line of basically the family being able to move on. Does that make sense?
Yes.
Question in the back.
So if there's a couple that remarried, and they have children not by that spouse, and if something happens to that one spouse, who gets?
Okay, so
Who gets the
basically, there's a
property
question
or-
basically about what happens to property if there's a married couple, like a second marriage,
Right,
and there are children from a previous marriage.
correct.
So again, it depends. If there's a will, that kind of trumps everything. Spouses are entitled to the first $15,000 of the estate. So there's a little protection there. But if there is a spouse and children from a previous marriage, they can inherit. Spouse can get half the property, kids get the other half, in general, unless there's a will, at least in Kentucky. So, all right. I'm going to talk a little bit about trusts because we only have about 10 minutes left. All right, and trusts are kind of a hot button issue. So, okay, so there are generally two types of trust. This is very, very general. There's a revocable trust, which you sometimes hear called a living trust, and there are irrevocable trusts. Difference is one of them you can revoke or change, and one you can't. It's pretty simple. These revocable or living trusts were really popular in the early 80s and on, they're still actually very popular. They were great for tax planning at one point. Does anybody know how much money you have? Where's the threshold after you give so much away that you will pay a tax on it? How much can you give away without paying taxes?
10,000?
15.
Okay, so the answer is actually 11.58 million. So if you give more than $15,000 away, you have to file a gift tax return, which just reports the gift, but you're not actually going to pay a tax on it until you hit $11.58 million. If you have $11.58 million, I can help you. I'd be very happy to, but most people don't need these revocable trusts for tax planning anymore because most of us just don't have $11.58 million. I don't, I'm happy to tell you. So there are other good reasons to do these trusts. Probate avoidance is one. If you have privacy issues, that's when you would really want to avoid probate. If you're a well-known public figure in the state, or if you have like a troubled kid out there who you know is going to cause problems, these trusts are a great thing to do. If you have minor kids, for example, I'll have one for my life insurance policy because if my husband and I die together somewhere, I don't want my minor kids getting handed checks for $1 million. I want someone else to be able to hold on to the money and distribute it the way I want it to be. So a trust to accept life insurance for minor kids, that's a great idea. If you have a special needs person in your family, someone with autism, somebody with Down syndrome, or an individual in your family who has money management or addiction issues, also a great device. I don't want you to think I'm telling you that people don't need these trusts, but in general, I think I downplay them a lot because they are way oversold. And the thing is, generally these trusts cost a lot more money than the value you're getting out of it. So a trust will probably cost you anywhere from $3,000, and I saw one recently as high as $10,000. So in general, for the common person, they may not provide you the protection you're looking for. To really make a revocable trust work, you actually need to title assets in the name of the trust. That means you need to retitle your house, your bank accounts, your car, everything like that. And the problem is, in general, people don't actually follow through with that. So I've only met a handful of clients who actually own their vehicles in the name of the trust. It's just not that common. And then for other accounts, the trust would need to be named beneficiary. So that's an easier process to do. But redeeding a house, retitling your cars, it gets pricey and just time consuming. But for the right people, these are great devices. One of the other things I talk about are irrevocable trusts. These are primarily used for asset preservation, especially if you think someone in the family is going to need long-term care and trying to figure out how to pay for it. There are some special needs trusts that are also irrevocable. So these can be great devices as well. It just kind of really depends on your circumstances, what your goals are, and the family situation. So, any questions about trusts? Yes.
I have it mainly for my pets because it's me and them, the family across the country. They're older. So I'm sure I could accomplish it in a will because I had a will prior to that. Just thought it might be safer because everything's so scattered to have a trust.
Okay.
I did that like a year ago.
So she said that she has a trust primarily for your pets.
Yeah, well,
Yep.
and that's finance for money and beneficiaries.
Yes, and that's a very It's becoming more and more common, these pet trusts. And so it's a good device if your fur babies, you really want to make sure it's taken care of long term.
And granted, they only have so much lifespan, but you know.
Yes, you want to make sure they're taken care of. Exactly.
So that's what-
These are also really great. If you own real estate in another state, a living trust can help you avoid having to do another probate down there. And so that is another example of what I recommend them. So I had a question to that.
The irrevocable trust, when you say that the grantor must give up all control of their assets,
For the irrevocable trust,
Right.
yes.
so what does that mean?
So in an irrevocable trust, you essentially are giving up control over something and putting it in a different pot and letting someone be in charge of it. After you execute that document, you can't control, really. There's a couple exceptions, but in general, you can't control, I mean, other than the document that you have written and signed, you don't have a say about what goes on with that stuff.
It's, so the person who has the trust, it's not, they don't have control of that?
So, okay, which bullet point are you at? Sorry.
I'm at the last bullet point.
Okay. Some irrevocable trusts can aid in Medicaid planning. However, the grantor must give up all control over the assets placed in the trust. Yes. So if you are creating a trust for Medicaid planning, it has to be what we call an irrevocable trust, which means you can't change it. And you can't have any indicia of ownership in those assets that are in the trust to keep them protected. So you would have to put them in a trust and you give up control. You're not the trustee. You're not the beneficiary generally. So it's really giving up control over a whole bunch of stuff. So that's why a lot of clients really have to weigh whether or not they're ready to do that. So
who controls it?
the trustee. So you have to appoint a trustee that you trust.
Okay,
Mhm.
so they could be a family member or.
The trustee can be a family
Okay.
member, yes.
That's
Okay. Question over here.
I can't say the word.
Irrevocable.
The last bullet point.
Uh-huh.
Can you talk a little bit more about how that works with, let's say it's a spouse,
Mhm.
one spouse is in a long-term care facility, probably gonna spend down to using Medicaid. How can that be used to protect
Okay.
the spouse who's not sick?
Okay, so the question was essentially, how do we use irrevocable trust for a married couple where one of them is going into a facility and one of them is not? So in general, I don't recommend these irrevocable trusts for planning when someone is already in a facility because you do need the 5-year look back when you do these trusts. There are other things to do for crisis planning. Say, for example, and this has happened before, a married couple, one of them has been diagnosed with Parkinson's, and you know eventually they'll need long-term care. You could put assets into the irrevocable trust so that the couple wouldn't have as high a spend down. There are some irrevocable trusts that create benefits for the spouse. For example, they can continue to live in the home if you put the home in the trust. But in general, you really need 5 years. And it's not going to create a benefit really to the spouses. What it does is it really creates benefit for the future generations. So, yes.
Do they have to totally own the asset? Let's say it's real estate that they share ownership with somebody else. So can the irrevocable trust give over control of the asset of that half of the real estate?
The question is, could an irrevocable trust own a partial interest in a piece of real estate? It could. So, all right. You all seem to have more questions about Medicaid, so I'm gonna click. Oh, I got like 2 minutes. Okay, so, all right. As far as paying for long-term care goes, if you all have time, I always suggest long-term care insurance. People in probably their late 50s through their 60s, once you hit 70, I think it gets too expensive. All right. Since you all have questions about Medicaid, I'm just kind of jumping, okay? So we care about Medicaid because it's the #1 payer of the nursing home bill, and there's 76 million baby boomers. Does anyone know how much nursing home care costs in the state of Kentucky? How much is it? Oh, okay. So we're generally looking about $7,000 to $8,000 a month, sometimes more depending on what facility you're in and what type of care you need. I did have a client once whose care was $26,000 a month. So she definitely needed more care. Okay, so to be eligible for Medicaid, there are 2 things you need. You need to be medically eligible. That's a little easier. financially eligible is more complicated. If your income is over $2,349, you need something called a qualified income trust or a Miller trust. I tell people not to worry if their income is high. For assets, essentially, if you are a single person, you get $2,000. Married couples are more complicated. I know I'm running out of time. A single person can have the $2,000, and there's some assets that don't count. So if you can keep a vehicle, if you can get in and out of it, you will have to get a letter from your nursing home saying you can get in and out of that. You also can have a prepaid funeral. Usually that's an asset. Married couples, Medicaid does a really complicated math equation, and some of the money will have to be spent down unless you all have less than $25,728 of countable assets. So essentially what they do is they divide your countable resources in half. And the person staying at home gets to keep half, and the other person has to spend their assets down to $2,000. So there are things you can do to spend those money on things that you can keep, like you can pay down the mortgage on a house, you can buy a funeral, you can buy a car. And then right now in the state of Kentucky, IRAs and retirement funds do not count. That's a big deal in the state of Kentucky. So a lot of other states don't do that. Ohio makes you cash everything out. So. All right, I've run out of time, so. Okay, you want me to keep going? Okay, so if you need to leave, please feel free. So as I tell people, Medicaid has a 5-year look back. Anytime you make a gift within the past 5 years, they're going to penalize you for it. So essentially the gift penalty is how much you gave divided by $200. It's actually $199.46, but $200 is free. There are exceptions to gift giving. If you are a caregiver child, the house can be transferred to you. If you have lived with your parent for 2 years preceding their admission to a nursing facility, and you can get basically affidavits from members of the community, like neighbors or church members, stating that you being in the home and helping them basically kept them from needing assistance earlier on. You also can gift things to a disabled child or a minor child. Medicaid defines minor child as someone who is under the age of 21. You can also give things to your spouse. And those don't affect eligibility because Medicaid doesn't care who owns it if it's a married couple. So sometimes, for example, if a spouse is going into a nursing home, we may transfer the house out of the joint names to the single person's, the person who's staying at home's name. So that is a gift that doesn't count. Kentucky does still allow something called half a loaf gifting. And this is a very complicated process I'm going to explain in about 15 seconds. So essentially, you can use the Medicaid penalty to make you eligible and still retain some assets. So if I give, if my mom gives me $100,000 and I get a Medicaid penalty of, I'm going to say 500 days. So we have a 501 day penalty. So over the next 250 days, I'm going to give back half of the money, $50,000 over those 250 days to my parents. So I'm returning the gift. So on day 251, I can go into the Medicaid office and reapply. And what I do is I show them that I gave back part of the gift. So they reduce the gift and they reduce my penalties. They're going to recalculate my penalty. And so they recalculate it to 250 days. Well, I'm there on day 251. So I've already served my penalty. My penalty is over, and I get to keep half the money. It is a weird math problem that Medicaid has not fixed in the state of Kentucky, and it is totally a legal way to save a little bit of resources. And the reason we do things like this is because the individual who's in the nursing facility who's receiving Medicaid gets $40 a month for their basic needs. So, or their entertainment needs. So that's clothing, it's shampoo, it's snacks and entertainment. I like to joke that I always spend $40 on myself today. At least it feels that way. I'm sure my husband does. So it's just really not enough to make ends meet for our loved ones. There are a lot of things that Medicaid doesn't cover, like dentures, hearing aids, glasses. So there are things we can do with that money to make sure our loved one lives a healthy and happy life. And that's one of the reasons we do the Medicaid plan. in the gifting. Now, if you have 5 years, we can do one of those fancy trusts and save some of the money, and there are some ways we can get the money out. But in general, the gifting is more, we see a lot more crisis planning because a lot of it's Medicaid does do estate recovery. That means if you were on Medicaid during your lifetime and you pass away, your family will get a very nice letter in the mail that says, "I'm sorry, Mrs. Patton died. She owes us $200,000 for things that we paid for her during her lifetime." And so obviously I'm probably not dying with $200,000 in my estate, but I might if I didn't check my beneficiary designations. I might if I own real estate jointly with my spouse. So there are things that I tell people to do to avoid this situation, because most of the time we have saved our money and we have a desire to benefit our loved ones down the road. I did some planning and help with a family who had already had an individual in the nursing home on Medicaid, and 2 other people in the family had died. Before this individual could receive his distribution, and we were going to do some planning so he wouldn't lose his Medicaid. He was in a motorcycle accident and been there 10 years. And before we could get him his distribution, he passed away. And so we wrote a $75,000 check to Medicaid. And I'm sure to God that it's not what his grandmother intended. And so I'm sure she would have much rather it had gone to other people in her family. But if you don't do proper planning, there's some things we can do on the back end, but you really have to think about the people in your family. I mean, when things like this happen, when the individual becomes disabled, you have to adjust your own estate plan. I have another client who is a very sweet lady, doesn't have a lot of money, she's widowed, doesn't have kids. Well, her sister is like a super famous doctor who has like things named after her. And her sister was going to benefit my client in her will. And we were, luckily enough, knew about this and were able to communicate that to the sister, who was able to give the money to our client in a trust as opposed to receiving it outright, because it would have all gone to pay Medicaid back. There are some exceptions if there's a surviving spouse or a disabled child or the estate is less than $10,000. And Medicaid recovery kind of comes and goes in waves depending on whether or not Medicaid has the funds to actually pay someone to do it. So, yeah. Also, if you're going to a facility and or if you're a veteran, I always suggest that you contact your VA rep and see what you may be eligible for. And then so in general, I just tell people to plan now because it creates a lot of peace of mind. It makes sure that what you want to happen happens, and that the people you want to assist you and help you make decisions for longer that are the right people. So, again, my name is Mary Patton. I will stick around if you all have specific questions. Thank you for your time today. I really appreciate it.